Ms. Bork, you're charged with the state jail felony offense of fraudulent use or possession of identifying information 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Fabrication.
It's admitted. Is there any evidence that Ms. Bork is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you are mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of fraudulent use or possession of identifying information, sentence you in accordance with your agreement to a term of 9 months in the state jail prison, time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Kimler. All right, good luck to you, ma'am. You can go back with the bailiff. And then,
In the front, I'm sorry.
ma'am, go with the bailiff.
My shirt, my brought.
Go with the bailiff. They'll take care of that.
She wants
Can I tell
her.
him bye?
Go. No, you should have done that before you came up.
He's on the other.
Go with the bailiff.
She wants her extra clothes in there.
Well, and if the bailiff might let her do that, but she should have piled it on.
She did. That too, she did.
Yes, sir. And if y'all can just sign that, and if you'll make sure and email the attachment to the clerk this afternoon.
Yes, ma'am.
Thank you.
You can call me.
I'm deleted.
You can do it.
Let's see, and I'm going. And we're going on the priors, correct?
Yes, ma'am.
Okay, let me,
Actually, Judge, it was indicted in state jail with priors. However, I've also filed a notice of enhancement alleging additional offenses that I believe gets it to a second degree. So in other words, it was indicted as a state jail felony enhanced to a third degree, and I filed a notice to enhance that further to a second degree.
all right, I'm printing out something so I can do. Make sure I go through, okay. And will he waive the formal reading of the indictment?
Yes, Your Honor.
Mr. And sir, you're Leroy Smith Jr. And Mr. Smith, in cause number 0052, you're charged with the state jail felony offense of criminal mischief from September 4th of 2023. The indictment alleges that you were previously convicted of the state jail felony offense of delivery of a controlled substance September 18th of 1995. And after that was final, you were convicted of delivery of a controlled substance, state jail felony, 2 cases, on January 16th of 2001. The state has also filed notice of intent to use prior convictions to enhance punishment. It alleges that you were also previously convicted of possession with intent to distribute crack cocaine and/or distribution of more than 5 grams but less than 50 grams of cocaine in the Eastern District of Texas on August 6th of 2002, and that on February 2nd of 1993, you were convicted in 2 cases of burglary of a building, which at that time was a 3rd-degree felony, I believe.
Not sure, Judge.
Anyway, and then after that was final, well, we need to know.
I've got the property, Judge.
And then burglary of a vehicle also on that date. Need to know what those levels
The
are.
burglary of a building, at that time, Judge was, looking at the judgment from February 2nd of 1993, was a 2nd degree.
2nd-degree felony. And so to the charge in the indictment,
For the record, Judge, that
Yes, sir.
burglary of a vehicle was a 3rd degree.
thank you, Mr. Coleman. And so to the charge of criminal mischief, how do you plea? And are all of those prior offenses true? Speak up, please. And are you entering your plea of guilty and true freely and voluntarily? And because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Jackson? Do you fully understand them? And do you understand, so it looks like there's no agreement, is that correct? Or is there a cap?
There is no cap, there is no agreement, Judge.
So it looks like you are just pleading open to the court. These papers show that your attorney is asking on your behalf for a deferred probation. Mr. Coleman has requested an 8-year term in TDC. But if we go forward this way, you're leaving your punishment up to me. And I want to make sure you understand you have an absolute right to have a jury come in and determine 2 things. The first would be to determine if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do? I do want to make sure you understand that I can do anything in the full range of punishment, which because of those prior offenses is between 2 years and up to 20 years in prison. Do you understand? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. Mr. Jackson?
No objections.
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you are mentally competent and you understand the nature and the consequences of this plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. It'll give me more information about you, your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and talk to Mr. Jackson about that, and he will present it to me on your behalf when we come back. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right? We'll see you back at sentencing. Thank you.
Thank you, Judge.
And make sure you get that document emailed over for the discovery.